Hi, this video is about the differences between a provisional patent application and a non-provisional patent application. Hi, I'm Derek Fahey. I'm a registered patent and trademark attorney with the Plus IP firm, and we're going to talk about some of the differences between a provisional patent application and a non-provisional patent application. Well, first off, let's start off by talking about just some basic information about patent law. So in patent law, the filing date of when you file your patent application is very important because generally speaking, the first person to file for the patent rights has the rights to the invention. So as always, who filed first, so who actually disclosed their information first. Now, there are two types of utility applications, or two main types, or that's the one we're going to talk about today. There's the provisional patent application, and then there's a non-provisional patent application. There are several other types, but we're not going to talk about those today. So the provisional patent application, first off, is never actually considered a patent. It will never be granted a patent. And that's because a provisional patent application is actually never examined by the patent office substantively. So it would never mature into a patent. A provisional patent application is like a placeholder. What people do is they will file a patent application called the provisional patent application, disclosing the invention, and in order to obtain a filing date. When you actually file the provisional patent application, you are allowed to say patent pending for as long as that provisional patent application is still active or has not expired, or until you file what's called a non-provisional patent application. The reason why many people will file provisional patent applications is because they want to lock in the filing date, but they also want to test the commercial viability of the product. A provisional patent application only lasts 1 year. After the end of the 1 year, you must actually file a non-provisional patent application, which I'll explain later, in order for the patent application to be examined and to mature into a patent. Well, you may be saying, well, why don't I just file the non-provisional right away? Well, a few things. One, a provisional patent application, generally speaking, is going to be less costly than a non-provisional patent application. And the reason why is the filing fees and the government fees that you would pay for a provisional patent application are much less than a non-provisional patent application. The second reason why you may want to file the provisional patent application is the provisional patent application is actually not disclosed to anybody else besides you. So you actually could, while you can say patent pending, you can keep the information you're working on secret. And that's important because you may be developing the idea further, maybe tweaking some things. You may actually not know what you think is inventive. And this comes into play if you have a good idea and you're fleshing out it in the prototyping stage and you're trying to work out the kinks. Many times, new improvements and inventive features are discovered during the development phase of the product. So for example, you file a provisional patent application, you keep tweaking things, you discover new things, and you continue on the development stage. During that 1 year, you may have additional things that you want to cover or to protect. So that's another reason why provisional patent applications are important. Now, the non-provisional patent application must be filed would have to be filed within 1 year of the filing date of the provisional patent application. The non-provisional patent application actually matures into a patent eventually if it's allowed to. So when you file the non-provisional, unlike the provisional patent application, it is substantively examined by the patent office to see if you meet the legal requirements for getting a patent. So unlike the provisional, which never gets substantively examined, the non-provisional does. Now, the provisional patent application has more legal requirements, is more costly, has more costly government fees. So generally speaking, it's more costly. The provisional patent application, you can actually, when you file a provisional, when you go to file the non-provisional, you actually can add new things. You can change the claim set, which is the nucleus of the application, because that's the benefit of the provisional, because you're not tied into everything that you're disclosing in the provisional. One thing to be cautious about is when you're filing a provisional patent application, you need to make sure you adequately talk about how to make and use and describe the invention properly. You need to disclose everything in the provisional application, and it has to be done right, because if you don't do it right, when you file the non-provisional patent application, in litigation, when stakes are at their highest, you have to look back to the provisional application to potentially establish when you actually have priority or when your earliest filing date was. So the provisional patent application needs to be properly drafted in order to be worth its salt. And quite frankly, you may actually never know it's properly drafted until you're in litigation where stakes at their highest, which is why I recommend using a law firm to draft a provisional application. Yes, you can do it self-help, but unless you're experienced in patent drafting, it may be more difficult and may actually cause you problems in the long term. So something to think about. But some of those are some of the differences between the provisional patent application and the non-provisional patent application. I hope you found it helpful. And if you have any questions, you can always reach out to me at Derek@plusfirm.com. Derek Fahey PA is our Instagram handle and also our TikTok handle. And if you're watching this on YouTube, please like and subscribe to our channel and leave me a comment. I'm happy to answer any questions. We do have some other videos about continuation of parts and bypass patent applications, which are different types of applications. But today, hopefully you found the differences, or this video helpful to learn some of the differences between the provisional patent application and the non-provisional patent application. Thanks for watching. Derek Fahey. Bye now.